Make sure your mics are on.
Michael Damon. Here. Mark Fidel.
Here.
Microphones.
Here.
Art Nelson.
Here.
Here.
Mr. Daming. Microphone.
The minutes are not included, Ms. Kirkmeyer?
No, they're not ready
Okay.
yet, so.
All right. Any objection to tabling that item? All right. Seeing none, that item will be tabled. We have one item under old business, and that is an application for text amendment to regulate medical marijuana facilities. And the commission will recall we took this up at length at earlier this month, in the month of July. And we were presented with a draft ordinance at that time. The ordinance that you have in front of you today are some changes that frankly I suggested. Those are my chair's suggestions for your consideration, as well as some changes that were suggested by our zoning council. So that's kind of where we left things. I'd suggest, I know you've all had an opportunity to look at this. I know you've had an opportunity to think about where we're going with this. To the extent that we have some debate, if there is any debate tonight, I'd suggest that that would be related to the distance requirements that are reflected on section 5. You'll see the distances that we suggested. And additionally, section 2 is an addition in that the MC district has been added as a district. I believe that was a consensus of the commission, at least those people that were here at the earlier meeting in July, to allow dispensary facility use within the MC district. So with that, those are just the changes and some suggestions for the commission's consideration. So just as a reminder, right now we have the revised ordinance that you have in front of you allows within the MC district the dispensary facility use as is it permitted use or conditional use?
That
Remind
would
me.
be a permitted use.
Be a permitted use within that's right, within the MC district. Also, the dispensary facility use would be a permitted use within the,
So, yeah,
LID district, along with the other uses. Those would all be permitted uses within LID.
right.
And then the conditional use for the dispensary facility would be contemplated within the PD district. So those are, that's kind of a suggested starting point for the commission. Additionally, you'll see that there's a 500-foot requirement with respect to schools, child daycares, or churches. There's a 1,500-foot requirement in that there's no marijuana use that is permitted within 1,500 feet of another marijuana use. There was a thought at one point in the original ordinance that we would regulate and in that we would not allow any use within 500, 250 feet of a residentially zoned district. My thought was that simply didn't have much of an effect, and I'm not aware of any, well, frankly, in my opinion, there's not much of a rational basis for regulating in that regard with respect to a residentially zoned district, given this medical use that's been authorized by the voters of the state of Missouri. But again, those are the changes. Those are the items. The regulations here are, for the most part, taken straight out of the state regulations that that the state of Missouri has implemented. So there's not a lot we can do with that in terms of having an odor control plan, a security plan. But we do have, the city does retain its zoning power and can regulate reasonably. Can't regulate these things out of town, but can regulate these things reasonably. And frankly, that's what the draft ordinance in front of you contemplates. So with that said, we'll open up to the commission. Mr. Nurnberger.
My first comment is, I don't have a problem with the AMC district or the light industrial district allowing the medical marijuana use. I would be a little bit concerned about it was going to be a use for that coming down the pike as far as a recreational use. So I don't know how we need to caution when we are changing our ordinance. I think we need to have something in there that would address that issue, because I think anybody that wanting to come in and doing medical marijuana wants to be able to do recreational as well once they get into space. So that's my comment right now.
So let's address that. So the fear, as I understand your concern, Mr. Nurnberger, and this would be a question for Ms. Carr, would be that somehow sanctioning this use as a medical marijuana use would then constitute some sort of binding precedent in the event that marijuana is legalized recreationally, and that the city would not be able to deny a recreational marijuana use in a particular zone and in a particular way for recreational use because it had already sanctioned it as a medical marijuana use. Is that something that the commission should be concerned about, in your opinion?
Not at this time, because if Missouri does choose to approve recreational marijuana, most likely, in fact, I'm 95% sure that the state is going to license those facilities in the same way that they license the medical marijuana facilities. And that at that point in time, the state law will dictate who can sell recreational marijuana, just like they dictate who can sell medical marijuana. In the event that Missouri chooses not to license those facilities anymore, or chooses that to say that anybody can go ahead and sell recreational marijuana, at that point in time, it's going to come outside of the category of pharmacy, which is how we consider the medical marijuana dispensaries right now. And we have zoned for them very similarly in the way that we zone for pharmacies. So if Missouri just decides to go with recreational marijuana and takes a hands-off approach, then our zoning is going to be, there's going to be a lot more that goes into the consideration of the zoning for those types of facilities when that time comes. But right now, they're licensed by the state where we're limited in what we can do. I mean, we do retain zoning authority, but we are limited in what we can do. So right now, we've put on as many restrictions as we can. And certainly, if the law for recreational is similar to the law of today, then we're going to continue to have as many restrictions as we have right now.
Does that address your concern, Mr. Nurnberger?
Well, I'm just kind of curious. Once they have the license, they're in the space, they're selling marijuana. Of course, they're going to come and want to have the state, they're going to apply to the state to get that recreational use to sell that as well. I don't think there's going to be more stores popping up just because of that case. I think that would be a given for them to do that. They would be more likely approved based upon their history of having sold the medical marijuana. That's just my opinion.
Right, and there's a really good chance that they would do that if Missouri decides to allow the recreational.
But what would happen with their business? They wouldn't be able to sell to the public? That would have to go out of business, or they could just sell the medical marijuana?
Well, most likely. First of all, we have taken all of the steps that we can take, that we're legally able to take right now in limiting these facilities. So we have to allow certain facilities. and because we can't just prohibit them altogether. So if you have a legally existing facility and Missouri decides to go recreational, then they have a really good chance of being able to sell recreational if the licensing system is similar to the licensing system of today. And there's really nothing that you could do to prohibit that if the regulations and the law is similar to what it is for medical marijuana.
But it's not as if the license would, to sell medical marijuana or to harvest medical marijuana would automatically transfer if
Right.
it would be legalized.
They
You still have to
would-
go
they-
through
I
the,
know they would have to do another application, but they would likely be able to be approved for sale because of their history.
Common sense.
Yeah, it just makes sense or whatever. I'm just,
Okay.
yeah.
Other questions from commissioners? Ms. Bilderbeck?
I have well, I guess first to tag on to what Mr. Nurnberger is saying, I think there should be some distance between residential. I don't think it should be butted up against a residential house. So that would be my concern, that we should have some distance. I'm particularly, like, if we're looking at the MC district, I'm looking at the north side of Manchester Road where those properties back up to residential. And I have a concern with that. I'm for allowing these, I mean, even if our attorney was not recommending that we, have to allow them in some fashion, I think that we should. But I do have a concern about that. I don't think that should be the case. And then the next question I have is, I'm having some trouble with my eyes tonight, so trying to read all this again and trying to differentiate the colors of blue and make sure that I understand this map. Distances around Brentwood public facilities, so maybe this is a question for you, Lisa, or for the chairman. This map is showing us, tell me where I'm wrong, is this map showing us what we're proposing based on the draft ordinance that Mr. Daming put together?
So at the last meeting, it was asked, which was very reasonable, that we go ahead and now take our buffer map that included distances from churches, schools, and child daycare, but overlay that on top of our zoning map for the zoning information. So the map that went out with your packet last Friday is the exact same map that's in front of you tonight. No changes made. The only thing is I thought it was still kind of hard on the colored map that you have with your packets to kind of discern still how, maybe the 300 and 500 foot boundaries would look. So I colored in the 300 and the 500 boundaries just for visual purposes. No changes, because I thought, well, you can pick up the outside ring and realize it's the 750 foot boundary, and you can go right around the center and see the 150. So this was just hopefully to maybe improve the visual a little bit. But again, that's the same map that was distributed last Friday.
So how this compares to the ordinance is that the 500 feet ring, which is
The
yellow,
yellow, correct.
that is what we have in this draft ordinance right now, the way it was revised, related to a distance from school, child daycare, et cetera, church.
That's correct. And if I could at this point in time, because I do think this is important, this map is a draft, just like the ordinance is a
Right.
draft. So, for instance, when we still looked, remember how, and this is something else we wanted to bring up, because at the last meeting it was brought up that perhaps we needed either some formal definitions or an explanation as to what constitutes child daycare, school. So that's what this is in this revised ordinance. But when we went ahead and created those, then there's a couple on here now that I would say would have to be removed from the map. And we're kind of talking about the storefront churches. So again, I just wanted to make sure that someone didn't assume that all the facilities are on here not subject to change. And so, this is the correct buffer map, so.
Okay, and I would reiterate my concern that I expressed at the last meeting, that I don't think we should be in the position of judging, like, which is a true church to us or not. Like, I have a church that I run and operate, not in the city of Brentwood, and we meet for services 8 times a year, because that's the way it works for what our practice is. And also we're renting space. So I would say, like, just because someone is, I wouldn't want us to get in the position of judging somebody's religion and in what manner they meet, and if we think it's a congregation or not a congregation, or if they have church every week or not. because I don't think that that's fair. So as we're amending language with that, I want to make sure that we don't cross over that. That's really important to me from a freedom of religion standpoint.
And Stephanie's here tonight, and but we as well would like to really kind of address that point a little bit more fully too. So
Okay, great. I have more questions then. Okay, so making sure I understand this. So the 500 feet, I've got that. So then the 1,500 feet from another marijuana facility wouldn't be on this because there's no facility yet.
correct.
So, and I see that here it had taken out any buffer between residential, and I'd like to see that come back a little bit. I'd like there to be some sort of a buffer, but one thing that, and we could talk about what that distance would be, I don't have anything set in stone, but like, for example, if this light blue, if it's the right color, the PD district, when you look on Brentwood Boulevard, if I understood the chairman correctly, and I was having trouble following you, Mr. Chairman, when you were going through the ordinance, because I'm having trouble seeing the words on the paper tonight, that light blue PD, are we saying that it would be allowed in PD or not? Okay, so I don't want to see this, I don't really think it's appropriate as a use on Brentwood Boulevard. I could see it in the Manchester corridor, I could see it in Hanley Industrial Park, but I wouldn't want to see it back up to residential property. And the way this is drafted, all those light blue PDs, which also could expand because of our future zoning map further into the residential areas, I don't think that they should back up to residential on Brentwood Boulevard. I don't think they should back up to residential in the MC district either. So if there was something to address that concern that I have, and then keeping in mind the church thing as you continue to work on that, then I would be okay with the proposal. But I don't know what that right distance is, Mr. Chairman.
Well, I don't think anybody does. It's within this commission's purview to identify what it deems to be a reasonable distance requirement.
Okay.
And I should say, within the PD as a conditional use, not as a permitted use.
Right.
So they would have to come before this commission and for the board to have that use approved within the PD district.
If we have some sort of a distance from residential, I would be comfortable with that. And I don't know if it's like 200 feet. Like, it shouldn't be like a church or a school, but there could be kids, living in a house, and that sort of thing. I don't think they should be right next door to it.
Would Ms. Kirkemeyer or Ms. Carr, how have other municipalities addressed the residential distance requirement, and what are your thoughts on the commission's and the board's authority to govern that?
Well, the constitutional provision says that local governments can set a distance requirement for churches, schools used for secondary and elementary education, and for child daycares. So that's it. They do not list residential property. So the way that you effectively put in a distance requirement from residential property is that you allow it in only certain zoning districts. And presumably what other cities have done is that would be zoning districts that already have a little bit of a buffer. So your more highly intensive commercial uses, they would be allowed there, as opposed to a low intensity use that might back up to residential. I think that you do have somewhat of a protection with your PD district, because you're saying that would only be allowed for with a conditional use permit. So you're going to be looking at a particular parcel. There might be a parcel in the PD district that is larger than other parcels in the PD district where it might be more appropriate. You're going to be looking parcel to parcel to see if perhaps there is a parcel that would be appropriate for that particular dispensary. So I would be leery about putting in a distance requirement just from residential, just because it's not named in that list for which a city can impose a distance requirement, but you do that through proper zoning.
Okay, given that, I don't think it should be allowed in PD at all. I think it should only be in the LID and in the Manchester, the MC district.
Even as a conditional use within PD?
Correct, even as that, because I know how hard it is on the conditional use permits, and you have to, you can't just be arbitrary. You have to have like good reasons and all of that, and listening to what the counselor just said, I can just imagine, having sat on the commission and heard those conversations so many times over the years, that it would be a very difficult situation if a developer came in and they wanted to have that as part of their development. And sometimes we don't always know what's going to go into a place either. They may come back later and then want to add. I mean, I could just see all sorts of complications and scenarios, and the cleanest way to do it is not to have it be allowed in that district.
Okay. Mr. Moran.
You're going to have to, I don't know as much about P&Z as all the other people in here, but aren't we guilty of maybe using personal values here? We don't seem to have a problem with Walgreens being close to residences or a church, and it's shipping out opioids and alcohol on a daily basis, which are proven killers of hundreds of thousands of Americans a year, people worldwide. I don't understand what the objection is to a medical marijuana facility in terms of having to park it in certain places when there's a lot of other establishments selling things which are just as harmful. And we don't seem to have a problem with any of those things. What is our organizational issue with medical marijuana? Because it's been passed as it's the law, and I don't know that it's really our job to say, well, we don't like that law, or that law means that these places have to be away from a school or whatever.
Other comments, questions from commissioners? We do have several people in the audience. Would anyone in the audience like to address the commission? Step forward, Mr. Welsh, and introduce yourself. And
Dan Welsh. I represent a client of mine that has leased a particular property that intends to use the use if permitted by the city of Brentwood. I appreciate the commission's comments here today. I appreciate very much the consideration to allow the use in the Manchester corridor. I think other municipalities have actually devoted their Manchester corridor for the use and kept it out of other parts of their municipalities, I think for good reason. It is a strictly commercial corridor, and that seems to make sense to me, so I appreciate the commission's comments in that respect. There was a comment made earlier that the rest of your ordinance complies with and mirrors the state's regulations, and I think that's largely true with one important distinction. The state regulations, and in particular 19 CSR 30-950404B3, is the section that details the measurement between the points of demarcation for the buffer. Your current ordinance contemplates, for lack of a better term, a measurement as the crow flies. The state regulations eliminated the as the crow flies methodology for calculating distances and replaced it with the section that I just cited, that 0404B3, which provides that measurements shall be made along the shortest path between the demarcation points that can be lawfully traveled by foot. And I think that is in particular important when you're talking about your Manchester corridor, when you have a highway, for all practical purposes, Highway 100, that delineates the north and the south section of Manchester corridor. So I would ask the commission to consider adopting the state's methodology for calculating buffer distances, word for word if you'd like, but in any event, move from the as the crow fly definition to the as the pedestrian walks definition would be my suggestion for consideration by the commission.
so are you suggesting that the way we have the measurement calculation right now is not compliant with governing law?
I'm not suggesting it's not compliant. I'm saying it's different.
Okay.
So as I understand it, and I'm working with what you had done from last meeting. So your 400.1960A4 distances described in this section shall be computed by direct measurement from any property line of land used for the above purposes to the nearest property line of the parcel. It does not delineate how one must get between those 2 points of demarcation. So I'm presuming that you mean as the crow flies, or as a mapper would map it out, whereas the state has adopted the methodology that I cited earlier, which is a pedestrian walking-based definition, which I think the state probably adopted for their own reasons, one of which would be the safety of pedestrians walking between the 2 points of demarcation.
From door to door is what the state contemplates.
But so there's two distinctions in the regulations. One, if it's a freestanding facility, the state contemplates, and that's in the regulations also, a measurement from facility entry point to lot line of church, school, or daycare. But in the event that the facility is part of a larger structure, like a strip center, it's from the entry point of the facility within the strip center to the lot line of the church, school, or daycare. But either way, you take the building wall or the lot line, either one's fine. If the point that I'm making is the methodology for calculating the distance between those 2 points of demarcation, I would submit, should be as the state has governed it, which is as the human being walks, as the pedestrian walks, not as the crow flies.
So the current way in which we're calculating that would be more restrictive than what you're suggesting.
Absolutely, which I think played a part in the state's decision to change the methodology.
Thank you.
As well.
Ms. Kirkemeyer, your thoughts on the measurement?
So I had those discussions with Ms. Carr, but I think she's probably can express it better. So
Yeah, so the state regulations specifically talk about the most direct route. So basically a straight line, just like someone walking. So someone walking is going to cut across. They're not going to go all the way across the street, down a sidewalk, and then across the street again. They're going to take a direct route. They're just going to walk across the parking lot, or they're going to walk across the street from one point to point B. And so even the regulation says the shortest path. And so that's the direct path. I think that the calculations are going to end up exactly the same. We can certainly change the language, but in just practically speaking on the day-to-day calculation, I think that they're going to be almost exactly the same.
Respond to that. The actual language, if you read it word for word, provides measurements shall be made along the shortest path, which is correct, between the demarcation points that can be lawfully traveled by foot. Lawfully traveled by foot means you're not allowed to jaywalk. Lawfully traveled by foot means you're not allowed to cross Manchester Road unless there's a pedestrian crossway. So to the extent that we're going to interpret the state regulations as requiring lawful traversing by the pedestrian, I believe that one must walk through pedestrian crossways and not jaywalk, which would be breaking the law.
And I would just disagree with that, and someone who's had to prosecute several cases of jaywalking. What the ordinances usually provide for is that you can cross the street. Every pedestrian though, if you're not crossing at a crosswalk, every pedestrian has the obligation to yield to cars. So if there are no cars, you can certainly use any point in the street to cross. But if there are cars, every pedestrian is required to yield, and they call that pedestrian failure to yield.
Then,
Go ahead, Mr.
Renee,
Walsh.
thank you. What you could do is just mirror the state's language, which would then leave it up to the individual applicants to determine whether or not they believe that their location is compliant with the regulations or with your ordinance as drafted, so that we don't need to debate whether or not jaywalking is lawfully traveling. That is one way of adopting an ordinance that mirrors the state's regulations and deals with a calculation methodology.
So one point, Ms. Carr's, the way we have it right now, which is Ms. Carr's formulation, certainly that's easier to calculate and take into account for the city. But a question from Ms. Carr, why wouldn't we just adopt the language in the state regulation?
You certainly could. I think, though, that when applications come in and when we're looking at this administratively, we're just going to have the argument that he and I just had. Okay, well, so are we going to take a surveyor out there, and then are we going to walk down the street? Are we going to see if, are we going to have this argument that goes on for weeks and weeks and weeks over the distance, or are we going to have something that is easily understood by the applicants coming forward?
And I guess I would add to that too, as well from the administrative perspective, is that I don't know that we've ever, as a city, had thought about the 1,000 separation distance, which is what's allowable by the state constitution. So I don't know, in my estimation, I kind of see if we have a less buffer distance requirement, then that also just kind of even, works into the favor. I hate to say compensates, but it still kind of, works into the favor of the applicant as well. And to me, it would kind of just, be a, even out, if you will. So that was another reason why I also thought it would be acceptable the way it was.
So commissioners, what she's saying is that the state does not allow the city to prohibit these facilities being more than does not allow it, a regulation for more than 1,000 feet, meaning you can't say it has to be 2,000 feet apart. You're limited to 1,000, and we're going all the way down to 500 feet. Is that right? Did I say that right?
Right, that's at least, is on the draft ordinance.
All right, Ms. Bilderback?
I think with
Thank you,
my-
Mr. Welsh.
I think with Ms. Carr's explanation about, because I didn't think it was illegal to walk across the street either at a different point. So I think with that and the simplicity of it, I think that makes sense. It's kind of a common sense thing. Because the alternative is we can adopt the state's exact language, which they don't even, when they promulgate regs change all the time, and, all of this stuff. The language doesn't have to be identical in any ordinance. Ordinances aren't identical to state statute. They just have to comply with them. So I think that it complies with the spirit of the statute. And if we wanted to use the state's language, we could just increase it to 1,000 feet. We could do that instead.
There's something else, Mr. Welsh?
Yes, just one quick point. Thank you, Mr. Daming. I don't believe that this municipality will be in a position to have to decide if a facility location is compliant with the buffer, because the state's going to do that for you. Each of these applicants has to attest that they are in compliance with the local ordinance, at which point, from my client's perspective, we just need to know what it is, at which point we're either compliant or we're not. But I really don't envision a situation where future applicants come to the city of Brentwood and say, I think my location is good and complies with your ordinance, because it doesn't work that way. You have to apply this to the state for a license, and the state conducts the analysis of the compliance with the buffer ordinance, not the municipality. So to the extent that you simply adopt the state's regulations in your ordinance, then you all won't be making that determination. You won't have to, because the state will make it for you.
Chairman Daming, can I also just ask, I'm without a minute taker tonight, so if we do have people that are speaking, if they could maybe just sign in tonight, that would be helpful. And also, there are extra copies of everything here, materials, if anyone in the audience would like the materials, so.
So, Mr. Welsh, what is your understanding of how the state will make that determination?
License applications will be submitted starting August 3rd through August 17th, at which point, by Constitution, by the Missouri law, essentially, the state will have 150 days to decide whether or not license applications will be granted or denied. So part of that review process will include a review of the attestations that the facility license is compliant. So those who are applying, such as my client, will have gone through this process and will have attested compliance to local ordinance, and then gone through a whole arduous process of applying to the state through all the other issues that are required to show compliance with everything else. At which point, we'll find out in early January whether or not we have been awarded a license or not, and that applies to every license applicant in the state.
So your client will sign an affidavit saying it's compliant with the ordinance, but the state isn't going to send someone out to actually measure the distance.
I don't know what the state will do, what level of scrutiny they will use in reviewing the attestations that are submitted. I suspect that they will not just automatically accept those attestations as true and accurate. They'll probably, in my opinion, do some degree of due diligence to ensure that what they have before them is accurate.
Do you agree with Ms. Carr that the distances would essentially hash out about the same?
I do not. I do not at all agree with that. And I just use my client as an example, 8513 Manchester. There is what appears to be a religious institution almost directly across the street from it. If you use a methodology to calculate the distance as the crow flies, I don't know what that distance is, but it's pretty short. However, in the event that an individual pedestrian, in my opinion, lawfully travels by foot one must walk all the way to the closest pedestrian crosswalk, cross over the street, and then cross back to enter the property line of the religious institution. And that's a much larger distance than as the crow flies.
Not that then, for the commissioner, it's irrelevant, the particular use is completely irrelevant. But thank you, Mr. Welsh, for
Thank you
your
very much,
thoughts
Mr.
in that
Commissioner.
regard. And that would also be at odds with Ms. Carr's determination and opinion that lawfully does not require going to a crosswalk. And so to the extent that, that we adopted Ms. Carr's, our zoning attorney's opinion as to how these things are calculated, it would not require a user or someone to go across a crosswalk and actually avoid jaywalking.
I think if you adopt the state's regulations and methodology for calculating, it's no longer up to the municipality because you've done what you've done. It's up to the applicant to determine whether or not they're going to spend the time and money to attest that they are compliant based upon what you all have done. And the state will say thumbs up or thumbs down.
Okay, thank you, sir. So this is, obviously, we're on the cutting edge here. There's no case law out there. There's been no legal interpretation of how to interpret. We have two good attorneys here, and they come up with two interpretations of how these things play out. With that in mind, Ms. Bilderbeck.
Thank you, Mr. Chairman. I'm not comfortable abdicating this to the state. I mean, just because the state has a statute doesn't mean that we don't also have our zoning ordinances. And I think it behooves us to be responsible for that and to make sure that it's in compliance. I don't want to punt that to some attestation that's given to the state. There have been developers who have been inaccurate with some of the things that they've submitted, not intentionally. I think that we have to do our due diligence on every application that comes to the city, which includes making sure that it meets our code requirements and that we can't just, say, oh, well, we'll just trust that the state's going to, make sure that it's in compliance. Like, I think that would be a mistake. And I do have, when you're ready to go back to it, another thing about the church language.
Sure, go ahead.
Okay, thank you, Mr. Chairman. So looking at the church language, my eyes are starting to focus a little bit better. Those buildings designed for an assembly of a large number of people. My church has 30 people that attend services. I have a problem with that. I think it's religious discrimination. And then, not that we're trying to be, I'm not trying to, whoever wrote it, I'm not trying to be critical, but, and then also is the size, the size of the building, obviously, if you don't have that many people, it doesn't have to be that large. I just think that we need to stay away from, if a church is recognized as a church by the state of Missouri and the federal government, I think it should be a church.
Okay, so we did actually have a conversation about that, Lisa and I. I think that the rationale, because I'm the one who was trying to come up with the definition of church before I actually got the rules before they actually published the rules. So, which contain a definition of church. Okay. So I was looking at the impact. The whole idea of the distance requirement is the impact that it has. And so, you certainly want to address something that has a significant impact. So I was looking at the larger congregations where the impact would be greater. So actually, after we talked, and after this, unfortunately, had to go out in your packets, right, we did come up with a different definition. So I'm going to give you two alternatives, one from the state regulation and then one that we came up with earlier. And that is, the first option is church shall include those buildings designed for an assembly of religious worshipers and actually and consistently used for religious worship. And then the state has come up with church means a permanent building primarily and regularly used as a place of religious worship. So there's two options there as opposed to the one that went out in your packet.
Could you read the second one to the states again?
Sure.
Please.
Church means a permanent building primarily and regularly used as a place of religious worship.
I like that. I think in both of them, one consistently and one regularly. My only concern would be that your traditional Christian faith would view that as a weekly thing. I would just want to be sure that we weren't requiring it to be a weekly thing, because not all religions meet weekly. But I really like the state's item of, even though I rent my facility, remember I'm talking about, I'm not just talking about my situation, and it's not in the city of Brentwood, but it makes me cognizant of these issues. I kind of like the idea of a permanent building, because if you have a rental facility that's being used for a lot of different purposes and it's only being used as a church sometimes and it's not owned by the church, I think there's a difference there. I mean, I know that would negatively impact some alternative religions, but I think that that's reasonable, like when you're talking about a zoning code. And it, all of those, the two that you just mentioned, get away from that large assembly concept, like what you think of like a traditional, like St. Mary Magdalene, or, you know, that seat hundreds of people, or, you know, even some small Christian Bible churches, you know, they don't have that many worshipers either. I mean, some of them are really pretty small. So I think getting that piece out of it, I think that really makes a difference. And then the question is what, and if the state statute says regularly, maybe it's a better word to use than consistently. But I think those are probably pretty interchangeable. And then my only concern would be in the interpretation of that, because some religions, you know, may own their building or have a permanent building, but they may not meet that often. So, yeah, I mean, I guess the only other thing about that would be if they had like a year-long lease or something like that, that would be something else to consider. I mean, it's not like if they're just renting one off, you know what I mean? Like if they actually have a lease and they built out a building, then that might be more akin to, maybe the word permanent wouldn't cover that situation, and maybe it should, because some churches can't afford, you know, to own their own space. Does that make sense? So.
Yeah, so, and under the state's definition, it does say primarily. We did include, when we were going through the churches and trying to see, you know, what would match up with these new definitions that we have the option of using, we did include the churches over at Hanley Industrial, and maybe, and I believe that they rent, but they came in and they did tenant finishes
Right.
specifically for religious worship, and so we did end up counting those.
I think that makes a lot of sense, because like I said, I mean, buying a building is really expensive, and trying to get to where your congregation or your people are, especially in this area, can be really expensive for a nonprofit organization, which a church is. So I think that's a good way. So something along the lines of where you're going, I'm comfortable with. It's so much better than what's in here. I really appreciate the information. Thank you.
I agree with that. I think the state definition is significantly better than what we have in our packet right here. There's the idea of large, the adjective large, and the square footage just seems very problematic. So I personally would have no problem adopting the state definition of church. Anyone else want to speak on that issue?
I would just like to ask Ms. Carr if we could take that regulation and use it, would it result in a material change to the map?
Yes, and only in one way when it comes to the churches. That would be on Brentwood Boulevard. It's the new, I'm sorry, I can't put an X on it. A new Wind International. They actually periodically rent a room in the rec center.
And so the rec center would not primarily be used for religious worship. They just happen to rent a meeting room there periodically, so we would take that one out, because the primary purpose of that building is the rec center and a lot of other groups that meet there, so.
We did rent there one time.
And then the other correction on the map too, when it comes to churches, the one at the very top with the, it was pointed out to me this past week that the Brentwood Bible Church, that one was demolished.
Right.
So that's two corrections on Brentwood Boulevard for the churches.
Anyone else want to speak on the church issue? Moran?
Sorry, thanks. Why do we need, just for my edification, why do we need to have a distance requirement at all? Why are we making people who go to church walk further to go get the medical marijuana?
The only reason why we're discussing it is because in the constitutional amendment, it did say that you can have a distance requirement from churches elementary and secondary schools and child daycares. I'm guessing that maybe there was some, that perhaps they contemplated, that it would be somewhat offensive, to religious worshipers or some religious worshipers. I don't know. But we've been given the authority to do this, and so it's under consideration. You're certainly not obligated to do it.
Thank you.
Mr. Nurnberger?
Just going my point, Paul's point, why we really have to have the distance? We don't have it for liquor stores, we don't have it for gas station, we don't have it for Walgreens and that sort of thing. So I don't think really there's any difference between that or the medical marijuana location.
Okay.
Thank you.
Commissioners? Okay. Would anyone else in the audience like to address the commission on this matter? Walsh, did you have something else?
It's more a question than anything. I don't have the benefit of seeing your packets, so I don't know what you have in the mapping. And my question for you is, RCCG Church of God, located at 8614 Manchester Road, which I believe is, if I'm not mistaken, city-owned property, if I'm not mistaken about that. I cannot determine from the revision from the last meeting to today whether or not that church is listed as a church that would create a buffer or not. And I also don't know if it's listed, if it would apply as a church pursuant to the state's definition if adopted or not.
It's listed here. You should get yourself are the maps included in this?
Yes.
Yeah, Mr. Welsh, go ahead. But Ms. Kirkemeyer, I mean, I see the RCCG City of God Church here. Is that what he's referring to?
Right, I mean, it's improved real estate, it's recognized by the state as a church. Website is still active. The last time I looked, I don't know exactly what their worship schedule is, but they still use it for a church, so.
So to the extent that you're concerned, as Ms. Carr said, about the impact, right, and you're wanting to allow the MC zoning as a permissible location within the city of Brentwood for this use, I would suggest that you take a careful look at institutions such as RCCG, and in the event that you're inclined to treat them as churches pursuant, to treat that entity as a church pursuant to whatever definition you adopt, my only suggestion would be to consider the impact on your MC corridor.
Why wouldn't RCCG City of God be a church?
I haven't studied the congregation. I don't know how many members it has. I don't know how regular it meets. I don't know what the long-term plan is for that church, if they intend to remain there. I know it's part of the Brentwood Bound project. It's, I believe, currently located within real estate that may have been purchased by the city of Brentwood, and the city may have plans for that particular location. These are the types of facts that give rise to questions about whether or not that entity is an operating church and intends to be an operating church for a long time in that particular part of the city. And that is, please accept this. This is of no consequence to anybody's personal view about what a church is and what it means. It's a matter of commerce and economics at this point, considering the fact that we've got a client who intends to operate in your MC zone and would like to do so and has always viewed Brentwood as a great, logical, and quite honestly, a desirable location for this use.
Obviously, your client's use is irrelevant to our deliberations, but it strikes me that if we adopted the state's definition of a church and your client decided that that particular church was not actually a church under that definition, that strikes me as a private matter for you to litigate.
Yeah, not dissimilar to the argument or discussion we were having about lawful crossing of the road. And absolutely, the state will vet that out. But I can tell you that my client is not interested in spending a lot of time and energy on something that it's not a very winning proposition. I can tell you that definitively. So,
Okay. Thank you. Anyone else in the commission, I'm sorry, in the audience would like to address the commission on this matter? Any other thoughts from commissioners? So a couple matters for the commission. One is we have a
Yes, we have copies of that, so that was still going to be part of our discussion tonight. Yeah, there's been some other inquiries from the office that at some point, when you're ready, we were also going to address
Let's
those
go ahead and
questions.
address those, because I think we're getting close to making some decisions here. So
Okay,
Go
sure.
ahead, Miss.
And you can start. I think I have one other than what you had, Alderman Leahy, so.
Andy Leahy, 2833 Manderley Drive. I'm reading the ordinance and I'm going to ask questions because I honestly am a little confused with what's in front of you. And I'd like to get your impressions of it so that when it gets to the Board of Aldermen, I've got a better understanding of what we're looking at. I'm venturing that most of this ordinance is mirroring state statute, and that what we messed with was distance from different locations. And that's where the city of Brentwood gets a little bit of its hand to be able to do it. In the state statute, it calls this medical marijuana. Though for your educational arrangement, the federal government and the state governments are at odds with each other because the actual studies and scientific or whatever research for defining it as a medical purpose haven't been done. Now, you've got testimonials from people that say, hey, I've got this disease and I've been using this and it helps me. That's marvelous. If it helps them work through, that's great. But there has been no physical, actual studies with controls and stuff to be able to determine that this is a medical use or not. It's a lot like when alcohol first came out, it was all for medicinal purposes to work with. In your bill, you've got different distances that you would like us to consider between different institutions. And in the state statute, it defines the school, it defines the church and stuff. It's staying within the license arrangement. But if the city is actually looking at, I just don't feel comfortable having this type of an institution next to this type of an institution, then I question, is the intent of all of this because there's a potential problem? And that problem is that we don't want to expose the kids to this? And if the school's got 200 kids in it and that's a good thing, let's keep it away from those 200 kids. Wouldn't the 3 or 4 kids in a home school or environment or in a daycare center at home after school or whatever, or underage kids that aren't even in schools, would you want them protected? Or because there's only 3 or 4 of them, it's not that big of a risk type arrangement? So I'm questioning how we define what we're trying to space out in order to protect someone, or just because we're trying to limit where we want to put something to work with. So I'm not 100% sold that we're doing ourselves a favor. Yes, if we put this institution in and someone is lucky enough to get a license, that they come to a business owner and get to rent a facility in our location, it brings money with it. The dilemma that I have, and I'm going to defer to you, Mrs. Carr, we take from the city side a lot of federal money to work with because we get grants and stuff to do different programs. Is there anything in those boilerplate grant arrangements that would prevent us from having money from a business that is not allowed to do banking because the drug proceeds aren't acceptable, that could put the city at risk with the grant money?
Well, are you asking me to
If
answer?
you can answer, I don't know if, Chairman, do you want to have a conversation or just let me ask questions and
Yeah, why
let
don't you
all
ask your questions,
Okay.
Alderman, and then we'll take them up.
to go after. On page 3 of your proposed amendment, down in 400.1960, the medical marijuana down in Part B, and you get into the 1,500 feet from a different establishment to work with. I question into the state arrangement, you also have those that are granted a card for allowing them to do home growing of medical marijuana. Now, under the state statute, if I'm correct, they're limited to a 6-plant arrangement. Do they fall in anywhere into this arrangement? And if you're going to allow such in here, is this an indoor or outdoor plant? How do I control that it stays just at 6 and I'm not going to grow 12 for my neighbor or any of this? You have in on your ordinance here that you wish to control the sale to 4 ounces within a 30-day period of time. How do you plan to monitor such? Is this under the HIPAA rules, or is someone going to turn in the monthly reports that say so-and-so came in and this is how much they accumulated? Or do we have something in a bill that we can't begin to enforce, so why have it in the bill? Should we strike it out? Under page 4, you get into section E where you say you don't want anybody under the age of 18 involved. What happens if I have this patient who is under 18? How do I get him taken care of? Your law says that you can't treat him, yet that's the whole purpose of what the disguise of this bill is that we're doing medical purposes and we should be able to get it. But they can't come in. Nowhere in your bill do you discuss the ability of online sales. If Brentwood is successful at having an establishment in our boundaries, would such be allowable? And if so, how do we work that through or address it? You do have on page 5, I'm at subsection I for operating plants and number 2, controlling odors. But if you're allowing home growing, is there any type of odor that comes with that? We don't address that in our bill. So I find a few holes in it to work with. You put at the bottom of page 5 and the top of page 6 that no person may distribute, transmit, give, dispense, or otherwise provide medical marijuana as a home occupation. So we're not going to allow it in the residence. But that home grower that's growing his plants, how do you control that they don't share it with their friends and grow more than 6 plants? These things open it all up to the point that where I'm headed with this whole bill and where the state is, you're going to go from the quasi, it's a medical marijuana, to recreational use. I think with that, you bring potential problems for the city. So the question that's in front of you all is writing an ordinance that would help control those problems before they become a problem, or potentially look at, can I draft an ordinance that says that the city of Brentwood does not wish to have any medical marijuana facilities in it? Because the problems that you all perceive it would have coming to us may outweigh any financial benefit that the city would get from it to work with. The last question I have is on the bottom of page section 7, that the medical marijuana dispensary facility should be considered similar to a pharmacy. We have absolutely none of these requirements for Walgreens or CVS or Target with their pharmacy or Schnucks. So if we perceive it as such, would we honestly then look at, let's just establish it as a business, establish a reasonable business license, and allow it to conduct business like any other business in the city? This ordinance is coming out of your committee. So what I'm throwing at you are different ways to approach and looking at it. I don't have any good answers. I have not received a single phone call, nor have any of my neighbors banged on my door wanting to discuss in favor or against anything. Because now, not a lot of people are aware that we're moving in this direction. So you all get to find the way to cut us and lead us through the path. Mr. Chairman, I thank you for the time, sir.
Okay, thank you, Alderman. Let's address Ms. Carr let's just take these one by one. So what would happen if the city elected to pass an ordinance prohibiting medical marijuana zoning within our city limits?
Well, that would be subject to a legal challenge, and that's not legally defensible because the Missouri Constitution specifically says local governments cannot prohibit these uses within your city boundaries. So you have to accommodate them, and if you did prohibit them outright, then most likely that would be struck down, and the city would incur legal fees to do that, and may be ordered to pay the other side's attorney's fees, and there might be other consequences.
Okay, thank you, Ms. Carr. The other point that the alderman referred to a couple times was home use. And my understanding is that this ordinance is zoning of facilities, marijuana facilities.
Commercial facilities, you're exactly right. So you're actually going to see a couple of ordinances coming to you at different times. We were under a time crunch for the commercial facilities because of the state licensing schedule, and that they wanted these regulations to be in place so that they could consider and they wanted the cities to be able to tell them whether a particular location complied with the zoning ordinance. So this is zoning of commercial facilities only. Your home growers, the people who are going to have up to 6 plants to use just for themselves, if they, let's say that they have more plants than what they're allowed, or let's say that they elect to sell it to somebody else, that's going to subject them to criminal prosecution. Several chapters in your code, in your municipal code, are going to be changed, and part of that is going to be changes to your criminal code. So that's going to subject your home growers to prosecution if they go outside of the limits that that they're allowed to grow and that kind of thing.
Finally, the age requirement that the alderman referenced, it's my understanding that's straight out of the state regulation.
It is, yep. And the 4 ounces is straight out of the state regulation. So what this does is, let's say that just like you have a liquor store, and they're not supposed to be selling to people under 21, but sometimes they do, and your police officers might conduct operations where they go in and check out to see if they're selling to underage people. So if they do, and if there's a habit of doing this, or if there's a couple of instances of that doing it, what the city can do is it can go in to revoke the business license. It can revoke a conditional use permit. If it's a conditional use permit, they can revoke the occupancy permit because they're operating outside of the law. So having these, we can certainly subject the clerk to criminal prosecution. If a clerk sells to somebody under the age of 18, if there's 18-year-olds going in there routinely, we can act to revoke or suspend the business license for a while because of the consistent problems, the violations.
So, Commissioners, we've been talking about this for 2 meetings now, and it strikes me that the 2 items on which there's been a significant amount of debate and input from the audience are the way in which these distances are calculated, and it strikes me that the options for this commission would be to adopt the straight line test that's currently before us, or to simply just adopt the state regulation and the way the state language currently reads on how to calculate these distances. Similarly, we have a definition of church in front of us, which it sounds as if it's been changed from the definition that we have in front of us. And again, do we simply just adopt the church definition with respect to the state definition of church, rather than trying to reinvent the wheel? So it strikes me, and of course, let me know if and please speak if you think there's other issues to take up. But it seems as if the consensus of this commission would be to move forward with this ordinance, subject to making an adjustment for those 2 issues. Mr. Nurnberger.
I think we had to determine what areas we're going to zone. The PD, the light industrial and Manchester Road corridor. I think that was some issue, what one would take up there.
Yeah, and I heard Ms. Bilderback make that comment and speak to that. I am personally fine. In particular, I think her primary objection was to PD. Actually, I think her exclusive objection was to PD And given the conditional use, I would suggest that that use would be acceptable. The other item that Ms. Bilderbeck spoke to was a distance requirement, a limitation vis-a-vis a residentially zoned district, and we heard from our zoning council that there's legal issues with that. So with that, is there any other comments from commissioners? So what's the will of the commission? First, on the church definition, is there any objection to simply adopting the state regulation, state definition of church, rather than the one that's in front of us? Okay, seeing none, that change will be made as an amendment by acclamation. How about the distance calculation requirement?
Go with the state.
Anybody have an objection to adopting the state definition, the state computation of the distance between these different uses? Mr. Ritter?
I guess my concern is two different determinations of legal or not legal crossing. I think the straight line is probably the simpler version.
True.
I mean, I just think it makes it simple. Then there's no, well, I can walk this way then that way, and trying to compute all that. I think the easiest.
True. My thought is we do have the state has made a determination as to how to calculate these distances, and I think this thing is fraught with litigation. I think we're going to have, like I said, we're cutting edge of this issue. There's no way to avoid litigation. You have two lawyers tonight that disagree. They've got language right in front of them. They disagree on how to interpret that language. That's how lawyers make a living. So I don't think there's any way to avoid litigation, and personally, I think that the state has made a determination as to how to compute these distances. So that strikes me as the safest way to adopt, understanding that there is some ambiguity there. Ms. Bilderbeck.
A solution for that, if we're going to do that, perhaps the attorney, Ms. Carr, and Lisa could look at again the distances, because if they determine that substantially changes what we have on the map in front of us right now, then that distance could be up to mitigate for the change in the way the distance would be measured. And then also, it's really important, and it just completely slipped my mind. Damn it. Sorry.
Just to come back to you?
Yeah, it'll come back to
Okay.
me. Thank
All right.
you.
Ms. Kirkemeyer?
And Chairman Damien, if we could just also, while we're on the computation of the distance, there was one other discussion that we had after this ordinance was set out, and it was in regard to if we had a dispensary that was in a strip center or a retail development center, and you have one storefront. So if I could possibly let
Of course.
so
Barb
then-
talk about that.
Yeah, so if it's a standalone structure, it's very easy. You measure from the external wall to the lot line of the school, church, or daycare. If it is in a strip center, you measure it from the door of that particular dispensary and to the lot line of the school, church, or daycare. So we would include that if we go with the state, and probably even if we adopt the straight line approach, we're probably going to put that caveat in there that if it's part of a strip center, it's from the door of that dispensary,
What would be the alternative to being from the door?
from the building as a whole.
Oh, okay.
Yeah.
That wouldn't be fair.
No. Yeah, Mr. Moore?
Question pertaining to that, what if the door is around the back of the building, or far side?
They talk
High
about
distance?
they talk about the nearest door to the church, school, or daycare. So it doesn't allow us to play games and say, well, they have a front door and a back door, and then so we're gonna, measure it only from this door. It's the one that's nearest to the church, daycare, or school.
Further discussion, Mr. Shipley?
I apologize. This has already been asked. I thought the meeting was at 7, and it's highlighted here that it started at 6, so sorry I'm late. What if it was the other way around? I noticed churches sort of tend to pop up. You see them now in strip malls, old grocery stores. What if there was a dispensary in place, and then a church or school or daycare wanted to open? How would that
It says it's then existing. So when a dispensary comes in with their application, it's what is existing at that point in time.
Thank you.
Other comments, questions from commissioners? Okay. What is the will of the commission as far as the distance requirement? To either adopt the straight line definition that's before us, or to simply adopt the state language as far as distance?
500 feet.
Anyone opposed to adopting the state regulation as far as distance
I remembered my point.
calculation is
Ties
concerned?
into that.
All right, very quickly, Ms. Bilderbeck.
To compensate for the staff's time and having to calculate that and the attorney fees that'll be involved, we can up the license fee. Can't we? To accommodate for that?
No, it's going to be the same license fee that apply to similar business uses, so, which is, I believe, a gross receipts type of business license fee. And if you were to, there's two problems with doing a separate business license fee for medical marijuana dispensaries. First of all, any kind of business license is a tax, and that would have to be approved by the voters. And then next, you have to have a reasonable basis for the classification. So since we already have a classification that includes this, which is, it's very similar to pharmacies and to those types of uses, and we already have a classification established, I would be hard pressed to say, well, this deserves a totally separate classification from that.
Yeah, that's a great, so much for my brilliant idea. I like as the crow flies better.
Okay. All right. I believe that Ms. Bilderbeck, I did not see anyone else that shared Ms. Bilderbeck's thoughts, but I guess we shall see. If there's no other comments, the chair will entertain a motion.
Chairman,
Here, Mr. Nuremberger?
I misunderstood. We're talking about the 1,000 foot instead of 500 foot?
No, we were looking at, Mr. Nuremberger, with regard to that distance computation, we're looking at the new section 5, 400.1960, new section B3.
Okay, yeah.
So that would be the section that would be replaced with the state distance computation, subject to ministerial changes by our legal counsel.
Okay, yeah, I understand now, yeah. Thank you.
Would you like to make a motion, Mr. Nuremberger?
I'll make a motion that we approve this ordering change ordinances with the church definition being changed and the distance and the state regulation being put in the ordinance.
Is there a second? Motion by Mr. Nuremberger, second by Ms. Schuring to adopt the ordinance as written with the changes of the definition of church and the distance computation to mirror the state language on those items. Ms. Kirkmeyer.
So there was only, I think, one other just minor change that Stephanie and I had talked about. Okay, two. Sorry about that, but I want to make sure we do this right and get this covered. One was, all of a sudden, when I started rereading it, I started thinking about how do I apply this 1,500-foot separation between medical facilities? Because probably, there's a chance we could get a couple of facilities. So if everybody's like trying to apply for the state license and there's so many in the queue, how do I apply that 1,500-foot ruling when there's 3 applications? Or, at what point do I use that separation requirement? So we kind of had some language built in to address that.
Well, actually, we were going to take care of that administratively on a first come, first served basis, unless you all feel differently than that.
But how we were going to do it was, we weren't going to change the ordinance, but the only way, I think a sensible way to do it is if we have, multiple proposals, that it would be tied to the building permit as a condition for the building permit to finish out the facility, and that, we would condition the building permit that they would have to get the facility up and running in 120 days or something. But does that sound right? So again, we wouldn't really have to change the nature of the ordinance, but I didn't know if anybody else would maybe have that question after we pass something, so I wanted to let you know how we would address that internally.
Yeah, no, it's a good point. I mean, Ms. Carr, how are other municipalities addressing that? First come, first served?
Uh-huh.
Okay.
And
Okay,
there-
so that's
there
not,
were
that
some
wouldn't
other
warrant
things.
any changes to the language. Is that right, Ms. Carr? Wouldn't warrant any changes to the language in our code?
That would not, because that would be taken care of administratively and then with the conditions on the building permit. So if you're comfortable with that, then we're going to move forward doing that administratively instead of making any kind of, setting up a separate process in the ordinance. But I do have two other changes.
Go ahead, Ms. Carr.
Okay. So some questions came up about whether we wanted a provision in here, and this would be under section 5 on page 5, a new subsection O, which clarifies that no facility can be a shared use. So you couldn't have a doctor's office and a dispensary all in the same office suite. A dispensary would only be used as a medical marijuana dispensary. You couldn't have a convenience store and a medical marijuana dispensary in the same office or in the same in the same suite if it's a strip center. So, and if it's a freestanding building, it's only being used for a medical marijuana dispensary or other medical marijuana use, but that they can't share it with another type of use. It's got to be the only use in that particular office or that particular suite or that particular standalone building.
Only in the event of a freestanding building.
Well, if it's in a suite in a strip center, so if they're renting out one suite then for the dispensary, that suite can only be used for the dispensary.
So either in a freestanding building or a single suite of a strip mall, only one use could be, it would not be eligible for a marijuana license, one of these licenses, if they're already engaged in another use.
Correct.
Okay. Everybody understand that? Any objection to it? Is there, Mr. Nurnberger
Would
and
add that to the zoning.
adoption of the
Yes.
same use language is been amended by Mr. Nurnberger. Ms. Scheuring, is that acceptable to you? Okay. All right, Ms. Carr?
Okay, and then the last one is to section 7 on page 6. This isn't just a clarification, so the dispensary facility clearly falls or should be considered similarly to a pharmacy, which is already subject to a business license, and that's based on gross receipts. What we did forget to add in here was the manufacturing aspect of medicinal marijuana, that it would be subject to the manufacturing business license facility that is a gross receipts tax. And then the cultivation and the testing facility, those would be the exceptional uses. So we just didn't get the manufacturing in there as a manufacturing use. So we would need to add that.
I see. So everybody understand that? So section 7 just needs to be supplemented to specifically reference the medical marijuana infused products manufacturing facility to be considered similarly to a manufacturing facility.
Correct.
Okay. And then the other ones, as it's written right now, would be considered an exceptional use. Issues with that, commissioners? Mr. Nurnberger, are you okay with
Add it
making?
to, yeah, that would be fine.
And Ms. Scheuring? Okay. So the amendments to the draft ordinance include adopting the state regulation, state definition of church, adopting the state language as far as the computation, distance computation is concerned, adding a section O within 400.1960, providing that only one use can be permitted within a freestanding building or within a suite within a strip mall. And then within section 7, adding language that provides that a medical marijuana infused products manufacturing facility will be considered similarly to a manufacturing facility for purposes of the business license requirements. Correct, Ms. Carr?
That's correct.
Correct, Mr. Nurnberger and Ms.
Yes.
Scheuring? Any further discussion? Mr. Ritter? So right now, it provides, the motion that's been seconded provides that the
Yeah.
PD conditional use, the other would be permitted.
Fine with
Any
that.
further discussion? Okay, roll call.
Chair Bilblack,
I'm going to vote yes with, and I'm just going to say that I'm not thrilled about the PD thing, and I'm very happy about the church change. I vote yes.
Martha Faza,
Yes.
Rebecca Jacobs,
Yes.
Jeff Moore,
Yes.
Paul Moran,
Yes.
John Nuremberg is yes, John Ritter,
Yes.
Lisa Sherling,
Yes.
Tom Chifley.
Yes.
Motion passes, Mr. Chairman.
Okay, very good, Mr. Nurnberger. Thank you, commissioners, for your analysis of this issue over the last couple of meetings, and thank you, audience members, for your input. Alderman, thank you. I'll move on to new business. Is there any new business? I see none. Aldermanic report. Any alderman like to address the commission? City planners report, Ms. Kirkemeyer?
So because of, again, the timetable for the state applications process, I think we should just make a note at this point, there has already been the public hearing scheduled for the medical marijuana-related use ordinance for the August 7th Board of Aldermen meeting. And so that will begin at 6:30 is the public hearing next Wednesday for that. And it is likely that perhaps a first and second reading might take place on the ordinance again because of the application process. But
Do we have to say the first and second reading is approved? That-
Oh, yeah, do we
Yeah.
need, should we do that, Ms.
Yeah.
Kirkemeyer? Should
I
we
would be fine to do,
make a statement as to the 2 readings being permissible?
certainly may. If you-
Do we need
I
to?
would,
I don't know. I don't think we've done that, but in a while, but if
Yeah,
that
we
was
have.
passed.
We've done it, but we haven't done it in a while.
Okay, at least then it's clear. It can be reflected in the minutes that way.
Is there any
It kind of
objection-
shows that you're supporting the first and second readings.
Any
That'd probably be a
objection
good idea.
to, in light of the timetable here, to recommending that the Board of Aldermen take this up 2 readings in the same meeting? Okay. Seeing none,
That
that's
will
the
be reflected in the
recommendation by
minutes.
acclamation.
Thank you. Okay.
Okay, no need for a subcommittee. Rationale, Ms. Kirkemeyer can handle. Any other business? Entertain a motion to adjourn.
So moved.
second?
All in favor?
Aye.
Any opposed? All right, stand adjourned.
I think Frank Denny's gonna have to look out before